or what I think we're mostly talking about here, which is discovery and its variants. Under the federal rules of civil procedure, and most of the states have very similar rules, you do not have to have perfection. That would be ideal, but the standard is reasonableness and proportionality. So as long as you've got a good process, one that seems likely to find the material you're looking to find if the issue is searching, things like that, that is all that the court requires. It helps when you're able to explain the process. You don't need the court's permission to use a technology unless the other side is going to object. So the easiest way to use some new methodology, AI or whatever, is to convince the other side that it's okay. The Sedona Conference, which is one of the top recognized think tanks in the e-discovery world, has a set of principles. And Sedona Principle 6, which has been cited favorably in many court decisions, says that generally the responding party to a document request is in the best position to determine what method it will use to search for and produce the appropriate responsive information.
I often tell lawyers who work with me, don't take your lawyer hat off in a discovery project. But at the same time, don't take your common sense hat off either, right? You don't need to employ excessively burdensome techniques to validate AI necessarily. You don't have to take a scorched earth approach. As Judge Peck says, the goal is not perfection, so keep that backdrop in mind. Being in the trenches over the years in a lot of discovery projects, privilege review projects, I can talk about this for hours, but I'll try to summarize in the best possible way. The privilege and PII review process is just fraught with challenges, as you mentioned, right? It's slow, it's tedious, it's expensive. You think about it, you're trying to make final privilege determinations, determining whether to redact or withhold documents, and or painstakingly trying to identify and redact personal and sensitive information. So very, very difficult and challenging. On top of that, privilege calls are very nuanced, right? So, you could be dealing with work product protections that could differ from jurisdiction to jurisdiction. Here in California, we might have slightly different laws related to work product than we do in other parts of the country, for example. You're dealing with agency principles, joint defense, common interest considerations, and not to mention the situations where lawyers are wearing dual hats, right? So the business and legal hat, and you find yourself in this difficult predicament of trying to parse out what is business advice versus what is legal advice. On the PII side, a lot of pain points there because inadvertent disclosures of personal or sensitive information can have significant financial, legal, and reputational implications and harms on a company, right? And historically, we talked about technology. A lot of this, Omar, couldn't be automated. Based on my experience, at least, traditional AI TAR tools, they don't really achieve the heightened level of recall that's required for capturing, let's say, privileged content. So what I mean by that, in a responsiveness review using TAR, as Judge Peck was discussing earlier, an 80% recall rate may be acceptable, reasonable, and defensible. On a privilege review case, an 80% recall rate is almost never acceptable, right? So if I went to a GC and said, 20% of your privileged documents are going to be produced if we use an AI workflow, I would venture to say that GC would probably say, Bobby, thank you, but no thank you, and maybe even use a couple of expletives along the way. So the margin of error is very thin, razor thin, I think, when you're dealing with privileged documents, just being the most kind of sensitive documents. I believe the first step, though, we talked about this earlier, and it goes to defensibility. Ensure that you have the sufficient pre-project safeguards in place. And what I mean by that is you have that buttoned up protective order, you have the right resources deployed, the right set of tools, you have an understanding of what your objectives are for that project, right? You just don't kind of blindly go into a project. But let's say you have the, first is kind of the prerequisites and you have them under control. Second, I think the goal is really to create a reasonable and defensible process with built-in QC and validation steps at each stage, right? And as Judge Peck said earlier, it's not necessarily perfection. So I usually implement some combination of statistical sampling and targeted analysis. So what I mean by targeted analysis, in terms of the documents that the AI algorithm is classifying as not privileged, for example, maybe we review all of the metadata for those documents, right? We see who the recipients are, we see what the subjects are about, and if anything strikes us as suspect, potentially privileged content based on the subject lines or the recipients, we can actually triage those documents for a separate kind of review. Maybe we want to run a small set of core privilege terms, and I don't mean a large set of thousands and thousands of terms, but if you have a data set and you have key players, key privilege issues, run a more truncated privilege screen, run that against the bucket that is deemed as not privileged, and see if you get hits, and maybe do some sampling or review depending on what your results are. Depending on the project, we may have certain custodians, right? If you're dealing with a counsel custodian, maybe they warrant a heightened level of QC. Or in certain situations, maybe we do a manual review over a more limited set of documents. So, for example, if there's a limited date range, let's say there's a 3 to 4 week period where key negotiations in your underlying matter were taking place, and you notice that you have this uptick of sensitive documents. You have drafts and content going back and forth between attorneys in that time frame. Maybe we take a closer look at those documents. Maybe we do a linear review on those documents.
What advice you might have for folks on the in-house counsel side?
Sure. So you've got to, when you want to introduce new technology, you've got to plan ahead for more conservative colleagues or counsel who want to see multiple layers of support in order to really get comfortable. And I think that that's the key word. It's not, do they think it works? Do they think it'll save money? Do they think it's defensible? It's, are they comfortable using it? And when there you want to have, like I said, multiple layers of support. One is, we certainly look to where is the center of gravity in the market and in practice. We want to be cutting edge, but we don't want to be on the bleeding edge. We don't want to be the guinea pigs, but we are willing to be technology forward. So kind of getting a sense of that. We talk to each other all the time about vendors, about technology. What are you using for this? What are you using for that? So we have a good sense of sort of what the rest of the market's doing. Do a proof of concept to show it works. And it's especially good if you use like an old matter, preferably closed one, and involve your outside counsel. Get an opinion from your discovery counsel as to what they think. Do they think it's defensible? What would they need to see in order for it to be defensible? And have a good validation protocol in place. The things Bobby was talking about, I couldn't agree with more. And I would also say, explain how it analogizes to other technologies that they might be comfortable with. And that goes back to what Judge Peck was saying about, different reviews with thumbs up and thumbs down. And finally, you want to show how the technology would fit into existing processes. What are you using it to augment or replace? And how does that impact the rest of the process? Is this an absolute, this new technology you want to introduce, is it a total revolution in how you're doing things? That's going to be tough to sell. But does it replace one discrete part or augment one discrete part in an otherwise unchanged process? That's a lot easier to get buy-in.
Really great points, Judge Peck.
I just wanted to jump in and, when you're talking about privilege review, the audience of, that you need to say it is acceptable, it is reasonable, is probably much less the judge and the court and much more Josh and the in-house counsel. Because when you're dealing with using technology, TAR or whatever, to produce documents, the court has to be convinced that you're giving the other side what they're entitled to. With privilege, the other side is not entitled to see any privileged documents. So The question isn't, is your process at 80% good enough for the court on privilege? What would I care as the judge? If I were the client, I would care very much. What do you mean 20% of my privileged documents, which may lay out all the problems, that counsel sees in defending the case, et cetera, et cetera. You got to convince the in-house team that this process is going to work.
Conducting POCs using past data sets and just comparing the past human coding with AI-based workflows for privilege identification, that's just critical. I think, if you can start to see, results where the AI is finding 98, 99% of the documents that humans log on a matter, you're starting to feel much better about the process, right? And there's this issue of defensibility, but there's also gut reaction and just making people feel more comfortable. And the proof is really in the data. So I would really encourage, all the things we talk about, getting stakeholders on board. The proof is really in the pudding, and just running that POC in a past matter. I can't tell you how helpful that's been to getting key client stakeholders on board.